Why is he out? Was a taser deployed?
Your Honor, when
I think that's either yes or no. Was a taser deployed?
Your Honor, as soon as saw him, she pointed the taser at him. He was running and pointed the taser.
I didn't ask that, Ms. Gaines. I did not ask that. Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video. Again, Your Honor, he's 20 years old. He has no prior history on an unarmed young man.
I mean, Ms. Gaines, I don't get it.
This entitled defendant walked into court facing some very serious accusations. He's alleged to have attacked 2 police officers, striking them, twisting one officer's finger, and causing an injury. On top of that, he's also accused of harming his former girlfriend, which only adds to the concern surrounding this case. What makes this situation especially frustrating is that this isn't someone who made a small mistake. Based on the allegations, this is someone who poses a real risk to others. Yet his defense attorney appears extremely focused on keeping him out of custody, going to great lengths to soften the situation and downplay the danger. Now Judge Simpson is left with a difficult decision. How much patience should the justice system give to someone facing accusations like these? Should the court offer yet another opportunity, or is it time to prioritize public safety and keep him behind bars where no one else can get hurt? Let's dive in and see how this unfolds.
As to bond.
Your Honor, we are just looking to address the condition of bond that requires that Mr. Hopkins be on house arrest. Prior to this matter, Mr. Hopkins was employed as a result of having the tether police. No longer able to, in this case, he was no longer able to maintain that employment. He is hoping to be able to get new employment and is asking that the court consider a no go-to order, a no contact order, or anything of that nature. My client, Mr. Hopkins, also recently registered for the cybersecurity program. Text me that information. I tried to send the confirmation to Ms. Barroso so that she would be able to see it. It's my understanding that the classes are majority online, but that would be the only place that he would have to come across Washtenaw County. Otherwise, he's just asking for some order that would allow him to work and just not have that kind of contact.
Response.
Your Honor, the bond in this case was set at $5,000 cash or surety when we requested a $50,000 bond. In this case, the people are uncomfortable with him being out. This was an event, or a series of events that occurred where the defendant assaulted the victim at not one but 2 locations. An eyewitness saw the defendant shove the victim while near the police station. The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts is an R&O causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So, hold on. There was a DV and then an officer injured. Why is he out?
Your Honor, if I could address.
Hold on. I'll let Ms. Barroso finish and then you can address it. I just had an intermediate question. Go ahead.
So at this point, I don't think that a modification of bond removing him from being on house arrest is appropriate. We objected to a nominal bond of $5,000 when it was originally granted. At this point, I don't think that any further reduction is appropriate.
A couple of things. First of all, Mr. Hopkins is here with his father. He is 20 years old. He has no prior criminal history. In reviewing the police report and the video, even the report references that the altercation, that the incidents that resulted in this charge, that there were.
In which charge?
I'll start with the domestic violence. That with those charges, that that there was a more complicated situation. I believe the officer said, the report says something to the effect of, and this would also go to the property, that there had been physical altercations between the two of them, fighting between the two of them, and breaking of objects between the two of them. So I believe that there's more to this than said. The allegations of the domestic violence are the one of the shoving, and also I believe Mr. Hopkins taking his own computer back from the complainant. That's the second allegation of the domestic violence. And the resisting and obstructing is, the allegations are that Mr. Hopkins, not that Mr. Hopkins turned around and slammed someone or punched them or anything, that he pulled away. The allegation is the officer fell and that caused the injury. And then that officer fell, yes, as he pulled away. And then subsequently, 4 officers who were, some of whom just pulled up on the scene in the video, all ran after him. And that's where the resisting and obstructing comes. And he did, in fact, eventually stop. It was not, it's not as if he were in a vehicle and went miles or hours away. He did stop running, and he did, once they complied, once that occurred, there were no further incidents. So.
Your Honor, I'm sorry, that is not the characterization of the R&O. The allegations include him punching 2 officers in the face, breaking free of their grasp, causing them to fall to the ground, twisting and seriously injuring an officer's finger. And then it went on for such a period of time that an officer had to point and deploy a taser. And that another officer had to point their pistol at a defendant. So at the defendant. So at this point, I don't think it was him passively.
Your Honor, I had an opportunity to view the video.
We watched the same video, right? Because it's honestly hard to understand how the defense attorney is presenting this version of events with so much confidence. According to her, the defendant struck an officer, ran briefly, and then calmly cooperated afterward, as if it was all a minor misunderstanding. But the state tells a completely different story. They say he hit 2 officers, seriously injured one by twisting his finger, and that the situation escalated enough for a firearm to be drawn. That's not a small gap between stories. That's a massive difference. These 2 versions don't even come close to lining up. At best, it feels like the defense is stretching the truth as far as it can possibly go. At worst, it comes across as ignoring clear facts. Yes, defense attorneys are supposed to advocate for their clients, but there's a limit to what sounds reasonable. Police reports don't just appear out of nowhere, and prosecutors don't casually invent details like this. What really stands out is how dangerous this situation appears when you step back and look at the full picture. Downplaying behavior like this doesn't just feel unrealistic, it feels irresponsible. I seriously doubt a jury will find this explanation convincing, and it doesn't seem like Judge Simpson is buying it either. We'll see how things unfold once the jury footage comes out, but so far, it's hard to see this defense holding up under real scrutiny.
Well, you had an opportunity to view the video. Let me ask you this. Was a taser deployed?
Your Honor, when
that's either yes or no. Was a taser deployed?
Your Honor, as soon as the officer saw him, she pointed the taser at him. This is not, as soon as she saw him, she pointed the taser at him. This is not a situation where he was running and pointed the taser.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video.
Ms. Burroughs, are you indicating an officer had to draw their weapon?
That is what was indicated to me in the file, Your Honor. Yes.
And then there's an officer that's injured. Again, we'll ask the question. I don't know why this individual's out.
Again, Your Honor, he's 20 years old. He has no prior history, and he has no reason to come back to Washtenaw County other than for school in this case. It's my understanding, I have not heard any information that he has had any contact with the complainant, has violated any orders. He is just asking to be able to go to work and to be able to get a job and go to work. Your Honor, would you want to hear from Mr. Hopkins' father, who's present?
I don't know what he could tell me at this point in time. I'm more worried about the bond as it originally is set. Does he have prior convictions for anything?
No, Your Honor.
That the original domestic was about. I mean, I'm trying to figure out, because I'll just tell you, I have some serious concerns that this escalated to a point that officers are having to deploy a taser, pull their weapon, and there are clearly enough officers around to, in my opinion, have subdued this individual without having to do all of that. So something else is going on. And
Your Honor,
I also have, I mean, one's bad enough, but I have 2 counts of domestic violence.
again, Your Honor, one of them is him taking back his own computer. That's one of the allegations. And that's why I'm saying there were things that were happening before this. That's not to excuse his behavior. That is to say that there's broader context. And in my view of the video, initially there was 1 officer, then there were 2, and he ran from 2, but as he's running from those 2, there are cars, 4 and 5 cars are pulling up with sirens on an unarmed young man who clearly panicked. This is not someone who's had police involvement, who has a history of contact with law enforcement and the criminal justice system. Again, I'm not excusing, but I do think that there's more. I think there are more nuances to this than the prosecutor does.
Well, explain some of those then. Because I've got a victim of a DV that's injured.
She is not the domestic violence person is not injured. It was the shove and the taking of there's no injury to her. You're right.
Domestic violence are 2 misdemeanor counts.
That is
felonies
correct.
here are 5 counts of are 5 counts.
Yeah, I see that.
Are no causing injury.
Maybe I misread that on the report, but
Yes.
the injury to the finger that's the officer.
That's correct.
Thank you. I don't understand this. I mean, there's a lot I don't understand. How, and I get there are resisting and obstructings that are filed that some may look at as questionable in terms of the charge. I get that. But I'm also trying to figure out how an officer gets injured, that there are punches to the face of officers. I mean, Ms. Gaines, I don't get it.
I understand what you're saying, and I'm saying I did not see any punches to the face when I observed the video.
I don't know what it is, but I'm really not convinced by this attorney's explanations. Everything about her delivery feels more like damage control than a clear and honest account. She's trying to frame this defendant as someone caught in a bad situation, when the facts suggest something much more serious. Based on what the state presented, this wasn't a misunderstanding at all. The allegations involve attacking 2 officers and attempting to run afterward. That's not a small mistake, and it's definitely not something that can be brushed off. When you actually stop and think about it, the state's version is disturbing, not exaggerated. If someone is willing to act that way toward officers, it raises serious concerns about how they might behave toward anyone else. This isn't about being overly harsh or dramatic, it's about safety and accountability. Someone who can't follow basic laws or respect authority probably shouldn't be walking free right now. I know some people are going to say this sounds too strict, but at some point you have to ask where the line is. How much more does it take before consequences actually happen? Let me know which side you're on, because from where I'm standing, this case feels very one-sided so far.
Tell you what, I'm certainly not changing any conditions. Can you explain to me one reason why I shouldn't raise his bond?
Your Honor, he has appeared for every court date. and he has not picked up any new charges. He has not had any contact with the complainant on the domestic violence or any of the officers. My understanding from him is that he has only come to Washtenaw County for court. He does not even reside in this county. It does not appear he's a flight risk, nor that he is a danger to the community. He is here with his father. He has come to every court date, and he's highly responsive to my calls and texts. And absent the no offer in this matter, we'd be looking to resolve it.
Anything else from the people?
No, Your Honor.
You know what? I'm not changing his condition in the bond. I'm not at this juncture going to up his bond either, although of rights I should. Of rights, I don't think he should be out around tethered or not, given that behavior. But I'll let Judge Perry deal with that after she hears the preliminary examination. Bond will continue. Motion for bond reduction or changing condition is denied.
Thank you.
He's 20 years old, accused of domestic violence, and then allegedly turned around and attacked 2 police officers. That's not a case of youthful poor judgment, and it's hard to understand how the defense tried to frame it that way. Hearing the attorney repeatedly describe him as just a kid honestly doesn't hold up when you look at the seriousness of the accusations. Age doesn't give anyone a free pass to hurt other people, especially when violence is involved. What stood out even more was how scattered the excuses sounded. When the strongest argument is that he needs to go to work, despite not having steady employment, it feels like the defense is grasping for anything that might stick. This situation also raises bigger questions about responsibility and guidance. When someone believes they can act this way without consequences, something clearly went wrong long before this courtroom moment. Courts tend to draw a firm line when it comes to violence against officers, and for good reason. Trying to downplay behavior like this only weakens the argument being made. If anything, this hearing did more harm to the defense's credibility than it helped the defendant. So what do you think? What kind of consequences make sense in a case like this? Thanks for watching, and I really appreciate the support.